Hey guys, Nedim Ramic here, your friendly car accident lawyer here in the St. Louis area. And I had a question the other day that people wanted to see my contingency fee agreement. So to give you a bit of a background, most car accident lawyers handle these cases on a contingency fee basis. And most of them charge 1/3 if the case settles out of court, meaning ends up, resolving as a claim. 90+% of all car accident cases actually resolve as a claim. The other 10% that we have to file in court that go into litigation, we then charge 40%, and all of those numbers are from the gross fee. So an example would be if we recover $100,000 for personal injuries for a client, we would get to keep $33,333, and the $67,000+ would go to the client, right? But even if the case is going to litigation, again, 98% of those resolve before we ever have to see a jury. And that's why clients usually don't ever see a jury. What I wanted to show you is our fee agreement, because that's what the client wanted to see. And let me just change the screen right here. And here we go. So this is what our client agreement looks like. So the first line is going to be about the client. So for example, Jane Doe car accident. And the second line is going to be who the attorney is. So it'd be me. The third line is going to be the date of loss. So what's today's date? 11/19/2020. 19/2020, and that's all that we need up there. The next statement is the fee agreement is a contingency fee agreement. Basically, the client retains Bajric and Ramic's law office as legal counsel in the above referenced matter and matters arising therefrom. Contingency basis. Basically, this right here says that we will get the 1/3 if it resolves as a compromise or settlement before suit is filed, and 40% of any amount recovered after suit is filed or after ARP or mediation is requested. We will pay all the expenses related to the accident, related to the claim or the lawsuit, and that amount is going to be recovered or deducted from the settlement amount. It is agreed and understood that this employment is representation is upon a contingency basis, and if no recovery is made, I will not be indebted to said attorney. Basically, if we don't make a recovery for the client, we will not get paid. We will never charge the client out of pocket for anything when it comes to this stuff. Also understood that the attorneys will not settle any claim without first consulting the client, which means that once I get the top offer or any offer actually from the insurance company, I'll sit down with the client, I'll have a settlement statement prepared, which will outline, the settlement amount, attorney's fees, expenses, and then what the client would get at the end. Also, we get permission from the client here in the agreement so that we can sign the settlement draft on their behalf. So once we settle the case, we'll get a check from the insurance company that's, written to the firm as well as the client. So we don't want the client just coming into the office to sign the check. We get permission from the client initially to sign that check and go from there. Appeals, if we go to trial, so the chances of this happening are slim, but if we go to trial, we win or lose, and there's an appeal going to happen, a separate agreement will be entered into. And then the last thing that we have to advise the client is that we're going to keep the file for an additional 5 years. So basically, we have to keep the client's file for a period of time. Much easier these days because of electronic, data storage. So they'll keep it for 5 years. Usually, it's much longer than that because of the electronic application of saving data. And so that's basically what the contract is. We date it, the client signs it, we sign it, and that's it. If you have any other questions for us when it comes to, here we are. So if you have any other questions when it comes to the fee agreement, please don't hesitate to reach out to me at 314-352-6800. Thank you very much, and you have a wonderful day.